Welcome to School Law Part 4. Today's presentation and lecture is going to be a catch-all of a lot of topics that encompass chapters 8 through chapters 12 of your textbook. So we're obviously going to move through some of this material quickly just to provide an overview as we have with all of the other lectures. We'll talk mainly about instructional programs, liability and torts, employee rights and employee requirements, and different trends both at the federal and state level. We'll start with some elements of the instructional program that kick into school law, starting with the curriculum. Much of the curriculum and the issues regarding the curriculum are really matters that are best handled at the state and local level, but there are some examples, such as the evolution issue and the teaching of different parts of science that have bubbled up recently into the court system. Edwards versus Aguillard, 1987 case, which was to contest and counter the teaching of evolution. Many of the cases of evolution have had disclaimers in science books, and some of this is on page 42 of your textbook, and the courts have consistently sided with the right of schools and the requirement of schools to teach evolution and teach based on science. The Fifth Circuit Court of Appeals, the U.S. Circuit Court, actually ruled this case that it actually countering the teaching of evolution, printing disclaimers, and even the use of intelligent design as an alternate form of evolution actually violates the coercion test, which we talked about, the coercing religion, and is devoid of a secular purpose. So the Supreme Court actually never heard this case. They actually denied certiorari by a 6-3 vote. This case seems to have settled much of that, although, as I mentioned, intelligent design also kicked in, and there's a follow-up court decision in 2005, Kitzmiller versus Dover, in which they determined that intelligent design was unconstitutional and a form of creationism. Let's shift to English language learners. Most of the focus on English language learners has really fallen under the Equal Education Opportunity Act and Title VI of the Civil Rights Amendment, and the questions regarding the segregation of English language learners in schools. The primary case regarding this is the Lau decision, and the Lau decision is a San Francisco-based Lau v. Nichols, 1974, in which the Supreme Court said that school districts needed to provide services to non-English language speakers. The Equal Protection Clause and segregation, of course, there's an extensive section in Chapter 8 of your book focusing on Brown versus the Board of Education, 1954, a landmark decision that's in every high school history book that struck down the notion of segregated schools. But the issue was not settled there. There was a secondary Brown decision that came out years later, and of course a very famous case out of the Jefferson County Public Schools that was rendered just a few years ago, that Meredith decision in 2007, along with a decision out of Seattle that also struck down the idea of assigning students to public schools solely on the purpose of achieving racially balanced schools. And again, that's partly part of the issues that Jefferson County has faced over the years in dealing with race and segregation. Title VI of the Civil Rights Act of 1974 focuses on the concept of disparate impact, and that's the idea that certain groups are treated unfairly and that policies are put in place that do not provide equal opportunities and provide a disparate impact between one group and another. And of course, the Constitution defines this notion of equality. All men are created equal. So that really has been interpreted in cases to mean equality of opportunity. There are several cases here. We've talked about the Lau case, and we will talk here in a moment about the Deborah versus Turlington case. And of course, the Wisconsin Yoder is another case that you all will need to look into that our time doesn't permit us to talk about here. We could teach a whole course on students with disabilities and the need to understand the law with students with disabilities. The notion of equality, like beauty, is often in the eyes of the beholder. But the book talks in chapter 9 about the John Rawls principle of the greatest benefit to the least advantaged. And there are certain examples when you get into that argument of equality where inequality and having this concept applied differently actually provides opportunities for students. And that is certainly a significant component in understanding justice as fairness. The idea that inequalities are justified based on the greatest benefit to the least advantaged, what is sometimes referred to as the difference principle. Most of special education, most of Title I, the idea that you have to provide additional resources to students in poverty, and of course ESL programs are really built upon the notion of the justification of inequality and the difference principle. So Public Law 94-142, passed in 1975, really created the basis for services and educational services to individuals with disabilities. The follow-up with that was the IDEA, Individuals with Disability Act, and the IDEIA of 2004. But oftentimes the courts have had to weigh into the disagreement between parents and schools in placement and what the individual education plan looks like, and of course the rights of the student when balanced with the rights and the safety of others. So this notion of free, appropriate public education in a least restrictive environment is very well articulated by the case study in Chapter 9, When Good Parents Go Bad. So the book does outline, and most everyone has had experience either taking course or working directly with special education and students with disabilities, and you understand the notion of child find and the zero reject rule of the December 1st count, the non-discriminatory evaluation that needs to take place, the appropriate free and public education, and the IEP, which came down with the Rowley decision, a landmark decision in special education that is part of your court cases here, the least restrictive educational environment, and then the whole notion of procedural due process and parent-student participation in the IEP planning process. Those are all pieces of the special education protocol, and all different points along the way where court cases have had to weigh in and provide interpretation for these sorts of things. Separate from IDEA is Section 504, which is actually not under the auspices of the Department of Education, but under the Office of Civil Rights. And this is providing accommodations and free and appropriate education as well. So there are all kinds of examples. Of course, one of the most important things districts can do is have a very good dose, a very good director of special education in providing the procedural safeguards to parents annually, which outlines legal rights and obligations and due process and procedures when it comes to things like medication, disciplinary issues and services. Those are all really significant, and there are a whole host of things in different court cases. The Deborah P. versus Turlington case, for example, struck down the idea of a graduation test. And the Mills case, as well as several other cases, have identified issues when it comes to due process and providing the least restrictive environment, disciplinary issues around providing services to students, and the idea of manifestation determination as the districts grapple with dealing with whether that behavior is manifest as part of the disability and how those students are treated. That's a fine line that courts have all worked through and that you need to take a look at. And the whole notion of supplemental services, which came from the Irving case, and the idea that everything from catheterizations to health services need to be provided. So the idea of supplemental services to students with disabilities is a huge area in that issue of IDEA. So Chapter 9 covers this, and we'll have some discussion about some of these issues. Let's move on to tort liability. Tort liability in the law of torts, notion of a tort is simply a civil wrong. It's laws that essentially are interpreted by courts. It's not a law made by Congress or a legislative branch. It's interpreting regulations and laws through the court systems when it comes to applying civil wrongs. The case study Girl Fight is a very good illustration of that, and all this with tort liability can be found in Chapter 10 of your book. The definition on page 186 is an important definition of the bottom line element of torts, and that is the concept of negligence. Negligence can be defined. There are several steps and several elements of negligence, and the ones that are listed here are very important to understand as a potential school administrator. The idea of duty is the first element of negligence, and of course duty when it comes to public education is the safety and the protection of the children that are in your care. Breach is a failure to exercise this duty, and cause in fact is the notion that any injury would not have occurred but for a breach in not exercising this duty. So cause in fact causation is an element of negligence, and that's one of the questions is, would this have occurred but for a breach of duty? Proximate cause is the whole concept of foreseeability, which is that it would be foreseeable. This problem, this breach is foreseeable by a reasonably prudent person. And then the final components are damages, and these are injuries that result from this breach of duty. So what are the defenses of negligence? The defenses of negligence, there are several listed. First is contributory negligence, or contributory defense to negligence, and that is where both parties, both the plaintiff and the defendant, have a shared negligence. They both contributed to the negligence. The assumption of risk is the notion that the parties involved knew of the risk and were conscious of the risk. And this is the whole issue of waivers. If you're going to climb a mountain, you are assuming risk, and you're signing a waiver typically saying that you know there is risk. Just like when you send children on a field trip, you know that they are going on a field trip, and that waiver is an assumption of risk. There's obviously a reasonable assumption and an unreasonable assumption in something like a field trip compared to climbing a mountain, but that's where you get into many other elements of the defense of negligence. Sovereign immunity, the state, the government is sovereign, so you can't necessarily hold the state responsible. States are sovereign from suits to protect districts, but individuals are not. So individuals can be held responsible, but this is a major question in the world of education, because districts are protected by this sovereign immunity as organs of the state, but individuals can have some risk of negligence. But there is also this concept of statutory immunity, where state laws do grant some element of immunity. The Teacher Protection Act of 2001 is an example of statutory immunity granted to teachers for some of the, as a defense of negligence when things go wrong, as they do from time to time. So how do you manage the risk of tort liability of these sorts of civil wrongs? Obviously, you buy insurance, because there are sometimes things happen and there's nothing at all that can be done to prevent things from happening. There are automobile accidents. There are things that are acts of nature that you can't always control, and that's part of why insurance is a way to manage that risk. Supervision is one that is within the power of administrators to make sure that your people are adequately supervising, and it goes back to this duty. Your duty is to protect those that you serve, and supervision is one way that you do that. Another way that you do that as an administrator, as a district leader, is to manage the facility and make sure that the facilities are safe and that facilities are not exposing you to any kind of risk in any kind of negligent situation because of safety concerns, where you have bleachers in a stadium that could fall down. Those are some examples of facility management that administrators need to know about. So typically, what are the types of torts? The types of torts that you see, the civil wrongs, you have things such as battery and assault, false imprisonment, intentional infliction of emotional distress. Those are some examples of the civil wrongs that you see, lawsuits and things relating to these issues. All right, switching gears in our miscellaneous segments here, from liability to dealing with teacher and staff employment. There obviously are a lot of different issues that apply to school districts as well as all kinds of other employers. There is the EEOC, the Equal Employment Opportunity Commission, and Title VII of the Civil Rights Act of 1964, dealing with things such as sexual harassment, hostile work environment, employment discrimination, the notion of disparate treatment, where you're treating different people in different ways, but also there's the notion of disparate impact, which is when policy creates inequalities. And then there are also things related to immigration. Many of these are listed in your book, and we are now in Chapter 11, and you can see in Chapter 11 there are a series of these on pages 212 and 213 that we're talking about: the American Disabilities Act, drug-free health insurance, family medical leave, Equal Pay Act, Civil Rights Acts that we've talked about, age discrimination, and the education amendments of Title IX all apply to your staff and to teachers that you work with. So understanding those issues as they relate to employment are important. It's also important to have good human resources personnel that can help you deal with misconduct and help you do the proper type of investigation of misconduct when it happens. And this proper investigation is important because oftentimes you will see or prove a failure to supervise adequately. So providing the documentation and providing the due process rights when you have to deal with misconduct, like oral, written notices, explanation of the charge, and providing evidence and the right to explain their side, and to report that misconduct. Of course, educational leaders have an obligation to report certain misconduct to the Education Professional Standards Board that governs this through state law and licensure, but also then dealing with things such as suspensions, but also dealing with handling resignation, non-disclosure, defamation, and of course non-renewal and termination. All those issues are issues that you have to adequately have good support from your human resources people. So dealing with affirmative action is another area that you have to deal with, and that is remediation of past discriminations. That is something that is often going to be something that has to be dealt with through employment. Your book talks about the BFOQ, and that's bona fide occupational qualifications. The idea that there are certain qualifications that are absolutely required, and so you are sort of allowed to discriminate in that case if there's physical requirements for certain jobs, if you must require certain people to speak English, for example, but you have to make sure that when you're dealing with some of these issues that if it is a bona fide occupational qualification, and that does make you immune to discrimination in some of those areas. So in talking about licensure and contracts, we've talked about the EPSB and the state law that requires and has oversight for licensure. And of course, in the teaching business, there is a contract business where most employees are under some form of contract. Most of your classified employees are at-will employees. Their contracts are year to year, and they can be removed for cause during the year. And at the end of the year, you really don't have to provide a significant reason for non-renewing their contract if they're an at-will classified employee. In your teaching world, you have a probationary contract, which is generally in Kentucky referred to as a limited contract. And that contract really is effectively an at-will contract for those in the certified teaching position, so they can be non-renewed, again, for cause during the year of their contract, but at the end of the year when their contract expires, they can really be non-renewed without giving any clause. Then there is the continuing contract, and that's a contract that is often referred to as tenure. That is the first day of the fifth year. The burden of proof then begins to shift, where you have to show cause even at the end of the year, because the contract is a continuing contract for tenure, and so there really is no end to it. And so the burden shifts from being able to non-renew for no cause to having to prove cause and show cause in the case for any kind of dismissal. The last form of contract that you see in the school business is a term contract, and this is usually only in the school system, is usually only occupied by the superintendent, sometimes by the board attorney, and that, for example, is typically 4 years, and they can be removed for cause. During those 4 years, it spells out how many board members and the like, but otherwise can be non-renewed at the end of the term for no reason. So employment of teachers and staff is a very important function of the school administrator, and dealing with that misconduct and dealing with the supervision of those folks is a really, really significant and important part of the job. Lastly, we'll talk about employee rights. Just like we talked about student rights, good teachers and other employees have similar constitutional rights, including those of the First Amendment and the Fourth Amendment. I'm not going to talk as much about the Fourth Amendment because the Supreme Court has really not ruled on a reasonable standard for search and seizure that is really differentiated from the whole notion of probable cause for most other adult type of situations. But there is a lot of cases out there as it pertains to the First Amendment. Of course, in the Fourth Amendment, there are some examples of drug testing and random testing and things like that that we'll get into, but there's not a whole host of search and seizure cases. But let's start with the First Amendment. The whole notion with the First Amendment and giving your employees the right to have free speech at the workplace and to create the marketplace of ideas is certainly important. There is a notion in education called academic freedom, and that's the notion that teachers have the right to basically have an open marketplace of ideas, and it's good for students to participate in this open marketplace of ideas, but it is not unbridled. There was a time during the McCarthy era and the Red Scare where there were loyalty oaths and sedition in the classroom. Much of that has been overturned by the courts, and teachers do have the right to criticize the government and to criticize and to call into question certain ideas related to the American democracy and the like. When it comes to public concern versus personal concern, the courts are a little more muted in not giving teachers as much wherewithal to have fair comment. There is certainly courts have cited in the Pickering case and the Connick case, the two most important ones that we have listed here, the whole notion of fair comment on matters of public concern. The Board of Education is going to have a tax increase, and that teacher is a taxpayer and is talking about fair comment in a matter of public concern that the whole community is talking about, that is going to be protected speech. But when it's something that pertains to their job description, and when it's something that pertains to the notion of something that applies to them specifically and what they do that is a personal concern, the courts are going to probably be more inclined to mute that public opinion and say that the teacher doesn't have a right to discuss that openly. And then there's also the standard that came in the Connick case where you have public concern versus private concern, but then the notion of substantial interference, where if their point of view is substantially interfering with the process of education, then it's going to be a disruptive nature. The court is probably not going to side with their First Amendment freedom in that case. There's also a whole lot of issues related to social media, and that's why having acceptable use plans in the technology area is really hugely important. Let me back up for a minute. There's also a couple of cases, the Mount Healthy case and the Garcetti case, that talk about retaliations. That is, the court has been very cautious and cognizant of organizations retaliating against employees, and so organizations have to be careful about denying those teachers and those employees the freedom of speech when it looks like it's retaliatory. Okay, moving forward again to social media and technology. This is an area where there is a lot of cases that are bubbling up. Of course, again, generally employees have the right to free association. They have the right to be a part of all kinds of social movements, political movements, and of course in our current time we have a lot of these anti-government political movements. That is certainly within their rights. The big issue with social media, again, is a very similar standard to the standard in the Pickering and the Connick cases, and that is that on social media, as long as they are talking about things that are of public concern, then it's typically protected. If it gets into something that relates to their job description, and it gets into something that relates to a personal concern and a grudge, then potentially it is not going to be protected. Sexual conduct using social media has not been protected. So there is certainly this notion of a nexus between the posting and job performance, and working out that nexus is going to be important in making sure that you have a policy that's an acceptable use policy on Facebook and other social media for this sort of thing, because it is something that has bubbled up every year since I've been a superintendent. So let's close by talking a little bit about the notion of drug testing and random testing for employees. The Fourth Amendment, again, I said, is not really seen a reasonable standard when it comes to search and seizure that's anything different than the same standard that you would see applied to adults everywhere. But there is this notion of drug testing. If there is reasonable evidence for the use of drugs, then employees cannot decline a urine test. They are permitted, districts are permitted to allow that. And then the notion of random testing, it's permissible only for safety-sensitive positions, such as bus drivers. And again, the nexus that's here is so much with law. There's a nexus between the nature of the duty and the risk of injury to others. Now, the one thing that courts have come down with of late is that teachers are considered to be safety-sensitive positions. So it's not just bus drivers, not just people working in maintenance and other things where there might be a risk of injury to other people based on what they do. The notion of teacher supervision is considered to be safety sensitive for the students that they supervise. So those rights have generally sided with school districts being able to do that. The last thing, going back again to the First Amendment, is the notion of having the ability for teachers to maintain openness as far as the selection of literature, school plays. For the most part, the logic of Hazelwood decision, which again is the newspaper decision, and the Bethel decision, which is the decision about censoring speech of a student, has kind of been applied to teachers. School districts do maintain some control. Generally, academic freedom does have limitations, and for example, you can't show rated R movies, you can't expose students to pornography or obscenity. So curriculum control does ultimately rest with the district. The courts have been pretty clear. While teachers have academic freedom, generally the curriculum is a district decision, and if the district wants to determine that this piece of literature or this play is not appropriate for students at the level of the age group, then they certainly have the right to limit that. All right, the last thing that I want to talk about is a little bit regarding federal trends. And of course, ESSA is just out, and it's gone through the rulemaking process, and they're in the process of setting up regulations. And of course, our state is one of the states that's starting to work on the assessment system. The big focus here, the big trend here that we won't talk a lot about, is a general shift that you're seeing from the federal government having more control, as they did with No Child Left Behind, to shifting more of that control back to the state and local areas. The big area is the testing area, and again, they are relaxing a lot of those sort of things. The evaluation system is one that's received a lot of news, and of course at the state level, Senate Bill 1 was passed that has been a way for Kentucky to make sense and to begin to aggregate a lot of these federal guidelines at the state level. You've also generally seen at the state level a narrowing of student rights. You've seen the court denying certiorari to a lot of cases that relate to the rights of students and even teachers. Probably, there's a whole host of them. But one of them, the Vergara decision and the Fredericks decision out of California, have really you begin to see limiting teachers in opting out of unions, which is a right to work provision, and the whole notion of forcing folks to be a part of a union. Special education continues to be a major area that you see lots and lots of of cases coming out, as we've already discussed. Most of a lot of the special education cases are really focusing on restraint and seclusion, and providing more limitations with restraint and seclusion. And there are some cases, in fact, a national case that came out of Kentucky in Kenton County, which essentially showed that that you can go too far using handcuffs and tying students up. Other cases that are really significant are the cases that relate to the LGBT students, and of course the presidential election changed this significantly, because last May 2016, the Office of Civil Rights in the Department of Education issued a letter that basically changed the approach to the treatment of the bathroom issue, that students should be provided the ability to use the bathroom of their choice that they identify with. And the current administration has completely reversed that. And so the court case that was teed up, the Grimm versus the Gloucester County School District in Virginia, the Supreme Court had originally agreed to hear that, but when the Department of Education changed its course with the new administration, the court basically refused to hear the case on the grounds that it was moot, because that dear colleague letter, which they used as a justification, no longer stood. So there are several different lower court decisions on the LGBT transgender cases. Many of them are somewhat contradictory, so districts and schools are really faced with a very difficult course based on several different interpretations, and ultimately there will be a case probably that gets to the Supreme Court. I've included the National School Board Association Transgender Guide on the Blackboard site as a good guide to help understand those issues. The last federal issue is the issue with vouchers in charter schools. There's a lot out there regarding the charter school issue and the voucher issue. Most of what's happening with vouchers are reaffirming the right that states are giving some of the funding to students and their families to attend private schools. Probably the most significant recent decision was a decision, the Andrew versus Douglas County School District decision, and this is also a special ed case where the court ruled 8-0 that special ed students had the right to attend a private school at the public expense, and this could totally transform the issue of special education and the whole voucher debate, which we're going to see in so many different ways in our state, I think, in the future. Speaking of our state, a couple of trends. Of course, we've talked about charters and privatization. As I just mentioned, we now have a charter bill that has become law, and we'll begin to see, as there have been several efforts in the General Assembly to add vouchers and privatization to that. So this is going to be new territory in Kentucky law that you'll have to pay attention to as a trend. Student suicides, let me back up again. Related to that privatization notion is the notion of allowing students that are homeschool students and students that aren't enrolled in public schools to play sports. Right now, again, the General Assembly has had several different options for this. Nothing has passed yet, but this is a major area around the country that is starting to rear itself in Kentucky, and it could be a court case that decides this rather than the General Assembly. As far as student suicides, there is a case, Patton versus Bickford, which is a Kentucky case of a wrongful death of a middle school suicide. The claim that the student was bullied and that the district didn't do anything. And you know what you're seeing with this whole notion is it's generally very difficult, both in the federal courts and the state courts, to prove that the schools are responsible for the suicide. Districts are typically not liable because it's very, very difficult to prove. And of course, with the pop culture, the 13 Reasons Why, you'll see these sort of things popping up all over the place. The federal case is TK versus New York City Board of Education. This is sort of an extreme case, which courts like to find because they are affirming, and that is the student gained 13 pounds, missed 46 days of school due to bullying. The court said that still wasn't sufficient proof that the school was responsible for their suicide. So those are areas certainly of concern as administrators to pay attention to bullying and to be involved with that, but also to understand that there are certain elements that liability is very difficult to prove when it comes to those kind of situations, the tragic situations as they are. Data security is another area, looking at the Family Educational Rights and Privacy Act that we talked about the other day. As you see data breaches, districts are having to deal with this, and the state is having to deal with this with a lot of regulatory and safeguard measures. Employee non-renewals is always something that you see in the lawsuits. The most recent one, Brasser versus Denton, a non-tenured teacher was non-renewed. Asked why, the superintendent said because they could find someone better. The Court of Appeals said that the superintendent just had to be truthful. They didn't have to give, and they had to give a reason, but they didn't have to prove anything. They upheld the non-renewal as long as it was truthful and a reason was given. So the standard there for a non-renewal of a non-tenured teacher is still pretty much at will. We talked about special education, restraint, and seclusion, and we talked about bullying and harassment. The legislature has defined that, and that is something that is worth going and taking a look at and making sure your policy at the local level is consistent with the state level. That's something we're doing in our district. Most cases, even those with special ed students, say that it's very difficult to prove bullying and harassment, but it is also very important for school administrators to pay close and careful attention to these cases and to situations at your building level. That concludes this information in a catch-all manner, concluding the main topics of the course.